Welcome back to HR Insights with Godswill AK, where we simplify HR topics one insight at a time. Today, our focus is on the Nigerian Labour Act, a brief overview of its provisions, its protections, and importantly, its limitations in today's workplace, as well as practical advice for HR practitioners in relation to the Act. The Labour Act is Nigeria's primary employment law. Originally, it was enacted as Labour Decree No. 21 of 1974 and later consolidated as Chapter L1 of the Laws of the Federation of Nigeria 2004. It sets the minimum standards for employment relationships such as contract of employment, hours of work, protection of wages, leave, maternity protection, redundancy, termination, and other related matters. But while the Labour Act lays an important foundation, it has major limitations that have been identified by labor law experts, which we must understand as HR practitioners. The Act has narrow scope, mainly covering manual and clerical workers, leaving out professionals, managers, and today gig workers. Its definitions are also outdated, modeled on colonial era ordinances, and it provides limited protection for termination and redundancy with respect to giving or not giving of reason. It also fails to address modern realities like remote work and digital contract. These gaps mean millions of Nigerians remain unprotected under the Labour Act alone. Now let's look at the key provisions of the Act. One of the central requirements of the Labour Act is the contract of employment. Section 7 requires employers to provide written particulars of employment within 3 months of employment. The particulars should include the name and addresses of the parties, job title, responsibility, working hour, leave entitlement, sick leave benefit, and many more. Section 8 further requires that medical examination should be at the employer's expense. Case law has reinforced this. The National Industrial Court held in a court judgment that failure to issue a contract of employment after 3 years was unlawful under Section 7 of the Act, and damages were awarded against the employer. The lesson is clear. Every employer must issue a written contract of employment. The Labour Act also sets strong rules for wages. Section 1 requires that wages must be paid in legal tender. Contracts stipulating otherwise are null and void. Section 15 requires regular payment cycles not exceeding 1 month, and deductions are tightly restricted under Section 5. For example, there was an employment dispute that went to court. The court ruled that the deductions that were made from the employee's salary for some performance improvement plan without the employee consent were unlawful. The principle here is simple: no deduction without employee consent and proper authority. You may deduct statutory obligations like tax, pension, but you don't just tamper with employee salary without their consent. Section 13 requires that normal working hours should be set by the contract of employment or collective agreement, and workers are entitled to rest intervals of at least 1 rest day every 7 days. Any work beyond this will count as overtime, and it must be compensated. In a case involving a very popular telecom company in Nigeria here, the court found the company guilty of exploiting employees by not paying for overtime, and damages were awarded against the company. Employers must ensure proper records and fair compensation. Section 18 of the Act provides for annual leave of at least 6 working days after 12 months of service. There is even a provision of 12 days for younger workers under 16. Section 16 also provides for 12 days of paid sick leave per year, provided a medical certificate is issued. Courts have upheld this right consistently. In the court case, the denial of leave was deemed an unfair labor practice. The key point here is leave is a right, not a privilege. The Labour Act also protects workers' freedom of association. Section 9 subsection 6 prohibits discrimination based on trade union membership. No worker can be dismissed or prejudiced because they joined or refused to join a union. and this aligns with International Labour Organization principles and strengthens industrial relations practices. Section 54 provides maternity rights 6 weeks before delivery and 6 weeks after, with full protection against dismissal during this period. Nursing breaks are also mandatory. The court has affirmed that dismissal during maternity leave is unlawful. Section 59 prohibits child labor, except in certain circumstances described in that section. These provisions protect some of the most vulnerable workers. Section 11 sets out statutory notice period depending on the length of service, and payment in lieu of notice must be immediate. Section 20 governs redundancy, requiring employers to inform the unions or workers' representative of the reasons for and the extent of any anticipated redundancy, and apply the principle of last in, first out where possible. The Act doesn't fix redundancy payment, so negotiation is essential. Our courts, however, have encouraged fairness and proper documentation of the process. So, having reviewed some key provisions of the Labour Act, the question will be, what should employers and HR be mindful of? First, it is important to emphasize that even though the Act was consolidated as Chapter L1 in the laws of the Federation of Nigeria 2004, its substantive provisions have not been significantly amended since the 1970s, and employment experts have noted that the Act has not kept pace with changes in the economy and in the world of work. But generally speaking, employers should take note of this as principles that we can deduce from the Labour Act. Number one, always issue proper employment contracts. Respect working hours. Avoid unauthorized deductions from employee salaries. Grant leave entitlement. Follow fair redundancy and termination procedures. These are the minimum standards under the Labour Act, and compliance is non-negotiable. Finally, HR professionals are advised to view the Labour Act as a minimum standard, not a ceiling. Supplement it with contracts, policies, and international best practice. Stay updated on case law from the National Industrial Court. Integrate ILO conventions and continuously review your HR policies. By doing so, we build workplaces that are not only compliant, but also fair, competitive, and resilient. Thank you for staying with me on this brief journey through the Labour Act. If you found this helpful, consider subscribing to HR Insights with Godswill, where we continue to break down HR and labor law issues into clear, practical insights. See you in the next video.